Hi, everyone. My name is Rachel Marks, and I am the Director of Education here at SunRay. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures over $10 billion annually. Today's webinar is conducted by the incredible Jessica Murphy, a Massachusetts construction lien law guru. Today's webinar's topic is Don't Sign a Release Until It Passes This Checklist. So without further ado, I'd like to introduce the fabulous Jessica Murphy.
Oh, thank you for that great introduction, Rachel. I appreciate it. Good morning, everybody. As Rachel said, I'm Jess Murphy. I'm a construction litigator in Massachusetts. I appreciate SunRay hosting this. And let's jump right in and give you a down and dirty in the next 20 minutes. My goal is that you'll leave this with a couple of new nuggets of information that you can use next time you get a release. And these are considerations that you'll have for both when you execute a release that somebody else has given you, or if perhaps you've got release forms of your own that you're looking at and thinking about what do I need to do when I'm asking other people to sign them, are they still good for me? So, all right, jumping right in. If you have any questions, use the GoToWebinar chat box. I'll answer questions at the end or as I see them. And just a reminder not to put any confidential information or names in there. First step, and if you've had any webinars with me before, this is always my first one. I love this acronym, RTFC. Read the fill in the blank F word contract. Always one of my best pieces of advice anytime you get a legal document is just to make sure to read it. A legal document does not have to be written in such language that everybody can't understand it. So if you can't understand it, a good attorney can put it in language that you can. So whether you're getting it from somebody else or it's a form that your company uses, good idea to make sure that you understand it, but that you've read it through. Over time, are there changes that have happened and you're not, now that you've got two documents merged together, does it really all fit together? But have you read it all the way through? So that is my absolute first piece of advice, is read the contract. Check and see, do you have all the pages? Are there defined terms that are used? And by the defined terms, what you'll often see in the start of a contract is one of the parties might be identified as contractor, the other one might be identified as owner or subcontractor or supplier. So that instead of typing out a full legal name, every time we use them later on, we can just say contractor or supplier. That's particularly helpful if you're going to use these forms again and again, so you only really need to make a change in one place. But especially as we use documents over time, it's really important to know, are there defined terms that maybe we've pulled from another document that are never defined anywhere? Or are we defining a term that's not used anywhere else? So those are the things as you read through the contract, you want to be careful to note. And then last and most importantly is, does the document incorporate any other documents or terms by reference? Does it refer back to the terms of a purchase order? Does it refer to the terms of another contract? It is perfectly legal to incorporate another document by reference without having it attached. It's also perfectly legal and binding for you to not have seen that document before you execute it, but be bound by those terms. So take a look and see. Usually releases don't do this for the most part. That's something more you see with contracts, but does it incorporate any other documents or terms by reference? And make sure you have those if it does. All right, next step, we're going to get right into this checklist. These are the things that I think you should be looking for when you have a release that either you're asking someone to sign or you're being asked to sign. Here's our checklist. Parties, scope of the release, special considerations for the type of release that you may have, what are the payment terms, and what does the release say upon breach of a release. So when we're talking about parties, what we want is the full legal name and address of the parties to the contract. I always suggest that people use the Secretary of State's website. As far as I've looked, I probably have not looked in all 50 states, but at least for the states that I'm used to, and where you have so many entities that are incorporated in Delaware. Delaware is a state that has a free online search for the Secretary of State, as does Massachusetts. What's interesting to note is that a company needs to be formed somewhere, but they can be formed in Delaware, but be doing business in Massachusetts. They need to be registered with both the Delaware Secretary of State and the Massachusetts Secretary of State. They would be registered in Massachusetts as a foreign corporation doing business in Massachusetts, but now you can find them in 2 places. So check the full legal name, make sure that the full address, or at least a good address, is included in the release. For the parties, you want to know who's being included in a release. So sometimes language you'll see is going to be the name of the party, let's say ABC Company. You'll see something like, and its agents, insurers, officers, employees, contractors, subcontractors, attorneys, predecessors, successors, heirs, and assigns. This is pretty common language. What it's really saying is at its agents or anybody who's acting on its behalf, insurers are the people who issue any insurance, officers, employees, people who are working for them. Their attorneys, of course, we like to always include that in there, but that's really, again, going to the idea of an agent. Predecessors and successors are, hey, companies that come before us or after us, and heirs is that sort of same people who come before, people who come after us if you're talking a person, and assigns is anybody who you might assign those rights to under here. Those are all fine things to have. Contractors and subcontractors are parts that you need to take a look at depending on your circumstance, because if you've got a matter and you're entering a release with an owner, you might not want to release the contractors and subcontractors. So take a look at who those other parties are. For the most part, agents, insurers, officers, employees, attorneys, predecessors, successors, assigns, those are all fine. Contractors and subcontractors is something you want to take a look at. Verify that the signatures are legal, are legible, and make sure that you have the person type out their name so that you can find who it is if you need to look that up later on. And that includes, again, witnesses and a notary if you're going to have a document notarized. In Massachusetts, not required to have a release notarized for a general release. For a mechanic's lien, a discharge document that's going to be recorded with the Registry of Deeds does need to be notarized, but otherwise, most of your documents don't need to be. A notary is just an additional evidence that this document was signed with knowledge of what they were doing with full capacity. I think that there's kind of an overuse of this in the past, so I think people have gotten away from it after COVID, where it was hard to be in front of a notary in person. Optional point is to set it up for electronic signatures to make it easy to do. If you do that, just make sure that your release language, it says that the parties agree to have this executed by electronic signatures. And then that will be essentially a DocuSign, an S/ or some other sort of cut and paste signature. Scope. This is really the main thing when you're talking about what the release is. You want to know what is being released. Is this a general release where it releases all claims between the parties, or is it a limited release? And that's going to be a release limited to certain projects, to certain time frames, however you want to limit it. Those are the big terminologies here. You may see it entitled general release, general mutual release. You might see it entitled a limited release. Even if it has that title, that should be a signal to you to kind of look again at the scope, but you're going to want to read the language to figure out if it's a general or limited release. So the example language we have is a general release is going to be all claims, right to reliefs, demands, etc., between the parties, including but not limited to. So with that language, it may have some specifics in there, but because the main release is of all claims and rights between the parties, the first example language is going to be a general release. The second language says all claims, rights to relief, etc., between the two parties arising out of, the example here is invoice number 2, including but not limited to X, Y, and Z. Here, that second language is going to be a limited release, and it's going to be limited to only the claims that arise out of invoice 2. If you're already in litigation, you can say all claims related to or that could have been brought in the litigation, for example. When you take a look at the scope of the release, a lot of times it's going to say, and I apologize, that should say claims known and unknown, not claims unknown and unknown. So claims known and unknown, which means at the time you execute the release, whether you knew about the claims or not, they're going to be included. So consider whether you have any claims that have not currently been raised, but for which you might need to limit the release. So the example I always give here is the mailbox example. It was originally given to me as the running over somebody's cat example. I prefer the mailbox example. It's a little nicer. But always think about this when you're thinking about claims known and unknown. If you have an example where you're being paid on a job where you hadn't been paid on, and you're going to enter a release because maybe you're taking a discount or you simply want to just get these things resolved. If you enter a general release between your company and ABC company, if it turns out that an employee of ABC company had in fact come to your job site or come to your company site and run over the mailbox, that would be included in the scope of the release because it may be a claim known and unknown, anything up until the time of the release. So think about, is there anything else I don't know about? That's one of the reasons we often talk about limited releases if we're talking about two parties who have a long-standing relationship, because there might be things going on you're not aware of. If it's a one-off, general releases seem fine, but if there's ongoing business, for example, I always prefer a limited release. Time frame, it's not unusual to see from the beginning of the world until execution of this document, but again, just keeping in mind what the scope is. Typically, there's going to be a limited opportunity to release claims that arise in the future. So that's good to know, but typically they will be, releases will release everything up until the date the parties sign the release. Special considerations. So when you look at a release, think about whether there are any special circumstances here. Are you trying to have a release of a mechanic's lien? Before a lien has been initiated, it is illegal in Massachusetts to waive your rights to a Massachusetts mechanic's lien. So that means in the start of a project, you can't say, I'm going to enter a release and I'm going to give up my rights to a mechanic's lien unless you're being paid for the work you've done. And then think about if you're releasing a mechanic's lien and you have a recorded mechanic's lien or a complaint that's been filed, you need to address how the recorded lien is going to be handled and know that you need to take care of special timing considerations. Is your release one where you have a release of bond rights or an existing bond claim? Those may have some additional considerations that if you find yourself in those situations, good to just consult with an attorney to make sure you're protecting yourself, dealing with those things appropriately. A lot of times, even if it's just paperwork, making sure it's done right at the time is always good. It's hard 6 months later when someone needs a lien released to come back and try to figure out what had happened 6 months earlier. So I always prefer to take care of all the appropriate paperwork at the time. So think about if you do have a mechanic's lien involved with a release or mechanic's lien claims, same thing with bond rights or a bond claim. Those are things where you're going to want to take an extra look and make sure you understand what's going on and that you're handling it appropriately. So the last two things on the checklist are payment terms. Know who is paying and where and how they're paying. Are they paying? Make sure to include something along the lines of in good funds. Obviously, if someone bounces a check, the payment hasn't been made, but I always like to put in good funds in my releases. Also figure out if you're going to be accepting certified funds or wire. It's our firm's policy that with the increase of forgeries and things, the only type of payment we will take as immediately available funds are a wire. We will not accept a certified check as confirmed good funds. We still need to wait for that to clear. I suggest it's a good practice, especially if you got mechanic's liens rights that you're potentially giving up. If your mechanic's lien needs to be filed or the next step needs to be taken by Friday and someone gives you a check today, now you're stuck because you may need to wait for that check to clear. So if you are in that sort of time frame when you're dealing with a release, I always suggest you talk about getting payment by wire. Make sure you know when somebody needs to make payment by. And is it the date that they need to make payment or the date by which you must receive payment? Obviously, this one's going to depend on which side of the equation you're on. If your company is making the payment, it's good enough for you that it's a date that you must make the payment by. If you're receiving the payment, I always want to make sure the language is, we will receive that on or before a certain date, which puts the burden on the other party to make sure that those funds are in your hand by that specific date. And then the last thing about payment terms is to know, does receipt of the payment trigger the release? And that's important. If you're the party receiving the money, then you want to think about, when I get the money, that's when I'm going to be releasing my claims. I don't want to be releasing my claims before I actually get the money. And so, thinking about the timing of when the releases come in, if there are mutual releases in the document you're being given, sometimes it may be that the other party is going to release their claims as soon as they sign the document. But if you're the party getting the money, you're not going to release your claims until you get the money. The last thing you're going to look for here is what happens if there's a breach of the release, and what does that release say about it? Are you resolving all claims upon executing the release or upon completion of the payment? This ties in with what we were just talking about in terms of when that release becomes effective. What's interesting is this sets up two scenarios. Sometimes you have a situation where you enter the release and the release becomes the new agreement between the parties, and you can only pursue your claims that may arise after that for a breach of that agreement as per that agreement. So let's say you have a debt for $100,000, you're agreeing to take $75,000, you're going to sign releases. You enter a settlement agreement that has these releases in it, and if not drafted carefully, you could find yourself stuck with having to accept $75,000, even if they don't pay it. The other scenario will be that you tie the release and you only release that additional $25,000 and agree to release all other claims when you receive the payment. So that sets up the scenario where if there's a breach in that second situation, then you can still pursue the $100,000. You're not tied to the 75 because they haven't paid it. But those two scenarios can happen just with minor changes in the drafting. So when you're reading through the release, you want to know what does happen if a party breaches. Is there an alternative dispute resolution procedure that is going to be in the release? And what about jurisdiction and venue? Do you have a situation where your company and another company are in different states? Maybe the underlying contract doesn't speak to where things will be. If you're drafting the release, put in a jurisdiction and a venue, which would be the state and the court in which you can bring claims. Put those things in that are favorable to you. So to sum up, here's your one-page checklist of what you're looking at that you want to go through when you've got a release. Who are the parties? Who's being released? Making sure that you have all that information full and legible. What is the scope? General versus limited. Is it a mutual release? What do you need to know about what's being included in the scope of those claims released? Special considerations. Just give a second thought if you've got a bonding company, perhaps an insurer, or if you have a mechanics lien involved. Payment terms, obviously want to make that crystal clear, who's being paid, when and how, and what happens if that payment doesn't get made. That's 19 minutes of everything you needed to know on Massachusetts releases. Rachel, do we have any questions that came in?
Let's see here. Right now, I do not see any questions that have come through. However, if anyone here does think of a question after the webinar, please feel free to reach out to myself or Jessica, and we will make sure to answer any questions that you guys have. I want to say thank you so much, Jessica, for your time this morning and educating us on this important topic. You provided us with super helpful and extremely valuable information regarding releases. So thank you, thank you. For everyone out there, if you would like to take take a moment to review us on Google, we would appreciate that. And then if you just go to the next slide. Okay, so our next slide with Jessica is on Wednesday, October 11th from 9 a.m. to 9:20. The title is Getting Paid Faster with Liens, Bonds, and Contracts. So go ahead and register at sunraynotice.com/education. And next slide. And that is all we have for you today. So thank you, everyone. Thank you, Jessica. And I hope to see everyone on our next webinar. Thank you.
Absolutely, my pleasure. Thanks, everybody, and hopefully this was helpful. Take care. Bye-bye.